Excuse me. As I was about to come on, a sneeze was upon me. Good evening, everyone. I'm Dr. Priscilla, a native English speaker, and I live in the US. So thank you so much for joining me this evening. For those of you that will watch the live stream, and for those of you that will watch the replay, I'm very, very happy to invite you all to this live stream. And tonight, our topic is the Negro and the law. In honor of Black History Month, I've read for several evenings articles that is from the Gutenberg Press, and it is available for those of you who wish to follow or read on your own. You can find these documents on the internet. So just bear with me as I pull up my article for this evening. The Negro and the Law. This is written by Wilford H. Smith. The law and how it is dodged by enactments infringing upon the rights guaranteed to the freedmen by constitutional amendment. A powerful plea for justice for the Negro. Wilford H. Smith. The colored people in the United States are indebted to the beneficent provisions of the 13th, 14th, and 15th Amendments to the Constitution of the United States for the establishment of their freedom and citizenship. And it is to these mainly they look for the maintenance of their liberty and the protection of their civil rights. These amendments followed close upon the Emancipation Proclamation issued January 1st, 1863 by President Lincoln and his call for volunteers, which was answered by more than 300,000 Negro soldiers who, during 3 years of military service, helped the Union arms to victory at Appomattox. Standing in the shadow of the awful calamity and deep distress of the Civil War, and grateful to God for peace and victory over the rebellion, the American people who upheld the Union rose to the sublime heights of doing justice to the former slaves who had grown and multiplied with the country from the early settlement at Jamestown. It looked like an effort to pay them back for their years of faithfulness and unrequited toil by not only making them free, but placing them on equal footing with themselves in the fundamental law. Certainly, they intended at least that they should have as many rights under the Constitution as are given to white naturalized citizens who come to this country from all the nations of Europe. The 13th Amendment provides that neither slavery nor involuntary servitude, except as punishment for crime, whereof the party shall have been duly convicted, shall exist in the United States or any place subject to their jurisdiction. Just bear with me for just a moment. The 14th Amendment provides in Section 1 that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. The 15th Amendment provides that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Chief Justice Waite, in the case of the United States versus Cruikshank, 92nd U.S. 542, said, "The 14th Amendment prohibits a state from denying to any person within its jurisdiction the equal protection of the law. The equality of rights of citizens is a principle of republicanism. Every Republican government is in duty bound to protect all its citizens in the enjoyment of this principle if within its power." The same Chief Justice in the case of the United States versus Reese, 92nd U.S. 214, said, "The 15th Amendment does not confer the right of suffrage upon anyone. It prevents the states or the United States from giving preference in this particular to one citizen of the United States over another on account of race, color, or previous condition of servitude. Before its adoption, this could be done. It was as much within the power of a state to exclude citizens of the United States from voting on account of race and color as it was on account of age, property, or education. Now it is not. Notwithstanding the manifest meaning of equality of citizenship contained in the constitutional amendments, it was found necessary to reinforce them by a civil rights law enacted by the Congress of the United States, March 1st, 1875, entitled "An Act to Protect All Citizens in Their Civil and Legal Rights." Its preamble and first section are as follows. Preamble. Whereas it is essential to just government, we recognize the equality of all men before the law and hold that it is the duty of government in its dealings with the people to mete out equal and exact justice to all, of whatever nativity, race, color, or persuasion, religious or political, and it being the appropriate object of legislation to enact great fundamental principles into law. Therefore, be it enacted that all persons within the jurisdiction of the United States shall be entitled to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement, subject only to the conditions and limitations established by law and applicable alike to citizens of every race and color, regardless to any previous condition of servitude. The Supreme Court of the United States has held this salutary law unconstitutional and void as applied to the states, but binding in the District of Columbia and the territories over which the government of the United States has control. Civil Rights Cases 109 U.S. 63. Since the Supreme Court's ruling, many northern and western states have enacted similar civil rights laws. Equality of citizenship in the United States suffered a severe blow when the Civil Rights Bill was struck down by the Supreme Court. The colored people looked upon the decision as unsound and prompted by race prejudice. It was clear that the amendments to the Constitution were adopted to secure not only their freedom, but their equal civil rights. And by ratifying amendments, the several states conceded to the federal government that the power and authority maintaining not alone their freedom, but their equal civil rights in the United States as well. The federal Supreme Court put a narrow interpretation on the Constitution, rather than a liberal one in favor of equal rights, in marked contrast to a recent decision of the Appellate Division of the Supreme Court of New York in a civil rights case arising under the statute of New York Burks versus Basso, 81, New York, Supplement 384. The New York Supreme Court held this language. The liberation of the slaves and the suppression of the rebellion was supplemented by the amendments to the national constitution, according to the colored people, their civil rights, and investing them with citizenship. The amendments indicated a clear purpose to secure equal rights to the Black people with the white race. The legislative intent must control, and that may be gathered from circumstances inducing the act. Where that intent has been unvaryingly manifested in one direction, and that in the prohibition of any discrimination against a large class of citizens, the court should not hesitate to keep pace with legislative purpose. We must remember that the slightest trace of African blood places a man under the ban of belonging to that race. However respectable and whatever he may be, he is ostracized socially. And when the policy of the law is against extending the prohibition of his civil rights, a liberal rather than a narrow interpretation should be given to enactments evidencing the intent to eliminate race discrimination, as far as that can be accomplished by legislative intervention. The statutory enactments and recent constitutions of the most of the former slaveholding states show that they have never looked with favor upon the amendments to the national constitutions. They rather regard them as war measures designed by the North to humiliate and punish the people of those states lately in rebellion. While in the main, they accept the 13th Amendment and concede that the Negro should have personal freedom. They have never been altogether in harmony with the spirit and purposes of the 14th and 15th Amendments. There seems to be a distinct and positive fear on the part of the South that if the Negro is given a man's chance and is accorded equal civil rights with white men on the juries, on common carriers, and in public places, that it will in some way lead to his social equality. This fallacious argument is persisted in, notwithstanding the well-known fact that although the Jews are leaders in the wealth and commerce of the South, their civil equality has never, except in rare instances, led to any social intermingling with the Southern whites. Holding these views, the Southern people in 1875 found means to overcome the Republican majorities in all the reconstructed states and practically drove the Negroes out of the lawmaking bodies of all those states. So that now in all the Southern states, so far as can be ascertained, there is not one Negro sitting as a representative in any of the lawmaking bodies. The next step was to deny them representation on the grand and peded juries in the state courts through jury commissioners who excluded them from the panels. To be taxed without representation is a serious injustice in a republic whose foundation are laid upon the principles of no taxation without representation. But serious as this phase of the case must appear, infinitely more serious is the case when we consider the fact that they are likewise excluded from the grand and peded juries in all the state courts, with the fewest and rarest exceptions. The court sits in judgment upon their lives and liberties and dispose of their dearest earthly possessions. They are not entitled to life, liberty, or property if the court should decide they are not. And yet, in this all-important tribunal, they are denied all voice, except as parties and witnesses. And here and there, a Negro lawyer is permitted to appear. One vote on the grand jury might prevent an indictment and save disgrace and the risk of public trial, while one vote on the peded jury might save a life or a term of imprisonment for an innocent person pursued and persecuted by powerful enemies. With no voice in the making of the laws, which they are bound to obey, nor in their administration by the courts, thus tied and helpless, the Negroes were proscribed by a system of legal enactments intended to wholly nullify the letter and spirit of the war amendments to the National Organic Law. This crusade was begun by enacting a system of Jim Crow car laws in all the southern states, so that now the Jim Crow cars run from Gulf of Mexico into the national capital. They are called separate car laws, providing for separate but equal accommodations for whites and Negroes. Though fair on their face, they were everywhere known to discriminate against the colored people in their administration, and were intended to humiliate and degrade them. Setting apart separate places for Negroes on public carriers is just as repugnant to the spirit and intent of the national Constitution as would be a law compelling all Jews or all Roman Catholics to occupy compartments specially set apart for them on account of their religion. If these statutes were not especially aimed at the Negro, an arrangement of different fares, such as first, second, and third classes, would have been far more just and preferable, and would have enabled the refined and exclusive of both races to avoid the presence of the coarse and vicious by selecting the more expensive fare. Still, these laws have been upheld by the federal Supreme Court and pronounced not in conflict with amendments to the Constitution of the United States. City ordinance providing for separate streetcars for white and colored passengers are enforced in Atlanta, New Orleans, and in nearly all the cities of the South. In all the principal cities of Alabama, a certain portion of the streetcars is set apart and marked for Negroes. The conductors are clothed with the authority of determining to what race the person belongs and may arrest persons refusing to obey his orders. It is often a very difficult task to determine what race some passengers belong, there being so many dark white persons that might be mistaken for Negroes, and persons known as Negroes who are as fair as any white person. In the state of Georgia, a Negro cannot purchase a berth in a sleeping car under any circumstances, no matter where his destination, owing to the following statute enacted December 20th, 1899. Sleeping car companies and all railroads operating sleeping cars in this state shall separate the white and colored races and shall not permit them to occupy the same compartment, provided that nothing in this act shall be construed to compel sleeping car companies or railroads operating sleeping cars to carry persons of color in sleeping or parlor cars, provided also that this act shall not apply to colored nurses or servants traveling with their employers. The violation of this statute is a misdemeanor. Article 45, Section 639 of the Statutes of Georgia, 1895, makes it a misdemeanor to keep or confine white and colored convicts together or to chain them together going to and from work. There's also a statute in Georgia requiring that a separate tax list be kept in every county of the property of white and colored persons. Both races generally approve laws prohibiting intermarriages between white and colored persons, which seem to be uniform throughout the southern states. Florida seems to have gone a step further than the rest, and by sections 2612 and 2613, revised statutes 1892, it is made a misdemeanor for a white man and a colored woman and vice versa to sleep under the same roof at night, occupying the same room. Florida is entitled to credit, however, for a statute making marriages between white and colored persons prior to 1866, where they continue to live together, valid and binding to all intents and purposes. All right, well, I again want to say thank you so much for allowing me to read from the Gutenberg articles that are found on our website. Well, not my website, but on the internet. If you have comments that you'd like to make, I would love to read your comments. I want to first thank those of you who are watching the live stream, and I value your comments as well. And for those of you that will watch the replay and leave comments, I appreciate that as well. So I will be on hopefully tomorrow. Until then, Have a wonderful evening. Good night.